All right, well, welcome everybody back to the afternoon session here of the Alliance for Constitutional Sex Offense Laws. It's day 2 of our conference, day 2 of our 5th conference, our 5th annual conference, and the 2nd virtual conference that we're holding. As we said earlier, but bears repeating, we hope and expect that next year we'll have a face-to-face conference, and perhaps it will even be a hybrid conference, so that those people who wish or to participate this way virtually can do that, but yet other people will be able to be meeting in person. It all depends on the law school folks, and of course they want to keep us all safe, and we do appreciate that. So having said that, let's go ahead and start our presentation now. We're talking about the tiered registry law. It's something that Chance and I have talked about many times now. I kind of feel like we're a married couple here talking about the tiered registry law, but it's just the beginning, Chance,
because it's just beginning. You're right.
In the year 2017, this law was passed here in California, and our California Department of Justice convinced the legislature they needed more than 3 years to implement it, and they're still doing it wrong. So, or at least it's not as effectively as they could. So let's go ahead, start with the slides right here, and here we go. Next slide, please. I'm going to talk a little bit about the background for this, because I think it's really important for people to know what happened in California, but also to know what could happen in your state. So this latest version of a tiered registry law was first introduced by a state senator who happens to be Hispanic and who's a self-identified victim of sexual abuse. Talk about the perfect author of a bill, right? Unfortunately, however, he dropped the bill like a hot potato once he decided that he was going to run for statewide office. So Senator Lara, was not the ultimate author of the bill. Instead, it was Senator Scott Wiener, who is a Democrat from San Francisco, the city of San Francisco, and a very publicly gay man from the city of San Francisco. Need I say more? Anyway, even Senator Wiener, we started with one bill and it changed to a different bill. And the more important thing to remember here, not so much all these numbers, is that this bill, as was currently introduced, would have benefited about 90% of the people on our registry. Next slide. Unfortunately, that changed. So the bill, by the way, the bill that we requested here in our state capitol was a bill that would be based upon risk assessment, current risk, basically, that somebody poses to society, if assuming there's a risk. And what we got instead was a bill that was based upon conviction. And so that prior slide, we basically were expecting this law to benefit 90% or more of the people on the registry, which didn't mean anybody was going to be automatically removed, but would have allowed more people to petition for removal. And we optimistically expect 70% of the people on the registry today will at some point in time get an opportunity to petition for removal. So one of the final changes that was made here was that the final bill does not allow anybody convicted of a felony offense involving child pornography, or as I prefer to call it, unlawful images, to petition for removal. And this was a political compromise. I can't say it more times. I can't say it enough. This was a political compromise. Our organization did not agree to this change. Nobody, in fact, asked us if we would agree to this change. It just happened behind closed doors. So we almost lost the tiered registry bill, quite frankly. I still remember it was a Friday afternoon before Labor Day. This was back in 2017. And I was sitting in the hearing room when they basically killed the bill, the Appropriations Committee. This was the very last step of a committee to weigh in on this bill, and it got killed. It died right in front of my eyes. It was a very sad day. At this point in time, we've been working on it for almost 7 years, and I drowned my sorrows in a glass of wine and baked some brownies with walnuts and nothing more in it. So anyway, lo and behold, over that holiday weekend, a miracle happened, and really literally was a miracle. And our then current governor, Governor Jerry Brown, called the chair of that committee and basically said, you have made a mistake. You will reinvigorate this bill. And she did. but she got her pound of flesh as well. Not only her, that particular member of the assembly here in California, but also the people who contribute significantly to her coffers. And what they wanted was they wanted these CP offenses to end up on the tier 3. So in other words, that they couldn't petition. And again, I want to emphasize it's felony CP offenses. And we do have some lucky people who are convicted of misdemeanor CP offenses. And for them, they are on tier 1, believe it or not. So got tier 1, got tier 3. By the way, in just a moment, Chance is going to take over and tell you about what happened in the final bill. But one more bullet point for me here, and that was also the final bill does not benefit people convicted of 2 or more separate felony sex offenses. And you're wondering, what the heck does that mean? Let's just say in California, they like to stack the charges. So you might be charged of several felonies for one event. And so if that in fact is what happened in your case, it's going to help. You still can be helped, but for people that have 2 separate offenses on different days, perhaps with different victims, in fact, you're going to end up on tier 3. And Chance is going to explain the significance of those tier assignments.
Well, let me just say this. First of all, the bill as we would have seen it would have been based on risk and risk assessment. Unfortunately, it is offense-based. And it's broken down. Basic misdemeanors, most of which are, not very serious, end up in tier 1. Felonies end up in tier 2, and felonies, serious felonies, and some misdemeanors, not so serious, and non-contact offenses, not so serious, end up in tier 3 too. So, the final outcome is, to say the least, counterintuitive. So you've got a 3-tier system based on offenses and risk level, so to speak, because some people who should be in tier 2 are also in tier 3 because they're high risk. The only ascension down from tier 3 to tier 2 is if you can get out of the risk box and be put back down on the appropriate level where you should have started. So tier 1 misdemeanors, nonviolent felonies, minimum 10 years. And again, most of these are misdemeanors. Some felonies are in tier 1. Okay, tier 2, some violent felonies. Okay, and some serious offenses, but they're tier 2. For instance, 288A, considered mostly a serious offense, tier 2. You can go to the next slide, Carlton, if you would. Then there's tier 3. And that's based upon offenses that have high risk levels, should be very serious, repeat violent felonies, CP offenses, because of what Janice just explained, PC 288C, okay, and this is really an interesting anomaly because when we talked about getting 288A set on tier 2, we were really thinking about the entire section, not necessarily 288A. Okay, but 288A came in, was a focus. And what happened was we actually put enough pressure on Senator Weiner to back that plan. Unfortunately, it's very difficult to get legislators to understand globally everything. And so tier 2 now has 288As, but tier 3 has 288Cs, which are wobblers, which are misdemeanors, and which are lower threshold crimes. And when I say misdemeanors, what I mean is some are felonies, but some have been reduced to misdemeanors, all of which reside up in tier 3. And except for those solely on a tier due to risk level, well, let me put it this way. Again, as I mentioned before, if you're up in tier 3 simply because you're a tier 2 but high risk, you can petition after 20 years, I believe, to be brought back down to the tier 2. So, Janice.
All right. Thank you. No, you got it great. Thank you. So let's talk to you about what happens or what could trigger an extension of time for you to remain on the registry. So when Chance was talking earlier about the minimum number of years on the registry, they can unfortunately be added to. So for example, if you were convicted of misdemeanor offense and you failed to register just one time, it's going to add an additional year. So for example, instead of 10 years, it's now 11 years. Okay, maybe that makes a big difference. Maybe it doesn't. I would want to be on the registry as little as possible, but it is what it is. Then when it comes to a felony offense, if you fail to register and you were convicted of a felony sex offense, unfortunately, it's going to add 3 years. So let's just say the same person, well, let's say you're on tier 2, which requires 20 years. Well, instead of 20 years, you now have to be on there for minimum of 23 years. Wow, that starts to add up. And not only that, but this is for each failure to register, right? And so you have to be really careful. Sometimes people get convicted of failure to register for a variety of reasons, which, by the way, will be covered in a breakout session later today. But the fact is that could be extended. Also, if you were convicted of a new sex offense or a felony, then these are things that could increase the number of years that you have to register before you're eligible to petition. But I want to say, if you have a failure to register, the fact is that alone does not make you ineligible to petition for removal. It just means you have to wait for a longer period of time. Next slide, please. Okay, so remember what I said. This legislation was passed in the year 2017. It didn't really go into effect until January 1st of this year, and only part of it went into effect on January 1st, another part on July 1st of this year, and yet a different part on January 1 of next year. So I'm still upset with the legislature for making us wait for so long for it to be implemented, but that's our reality. So again, what started happening in January 1 of this year? Well, the California Department of Justice was supposed to take the letters that they created and add them to this government-only database. I say supposed to. And first, they were supposed to create the letters. And second, they were supposed to be added to the database. And I guess third, that local law enforcement was supposed to distribute the letters. Trust me, there's a lot of flies in the ointment here. So California Department of Justice creating letters, I still have a big bone to pick with them. The fact that they're issuing any letters that say your tier is to be determined. So I bring up Frank constantly as an example. Here's another one. Frank was convicted in 1979. He's never been convicted of anything before or after his conviction in 1979. And Frank Lindsay got a to be determined letter. We don't know what your tier is. Oh my gosh, you are the people who created this system that's based upon the offense that you're convicted for. Why don't they look at their own darn charts and the law itself? It's so easy to tell that Frank Lindsay belongs in tier 2, but yet he's being told that they don't know what his tier assignment is. A lot of other people getting these letters. The biggest category, I think, is people who've been convicted more than 20 years ago. Why might that be? Because somebody actually has to look in the archives and go look at these old records. But folks, the courts are supposed to keep these records for 75 years. So Frank Lindsay was convicted more than 40 years ago, but he wasn't convicted more than 75 years ago. So come on, California DOJ, you have all the resources at your fingertips, which Chance and I and other private attorneys do not. Do your homework and get this done. Oh, by the way, California DOJ convinced the legislature they needed an additional 60 people for these tier assignments. And yet people are getting tier assignment letters that say, oh, we don't know what tier you're to be assigned to. And to make matters worse, when some of these TBD letters were first issued in January of this year, including Frank, his letter said, oh, and you cannot petition for removal until and unless we assign you to a tier. And they gave themselves an additional 24 months to make that decision. So now it's taken them 5 years to figure out that Frank was convicted of one felony offense in 1979, and it belongs on tier 2. And of course, tier 2 is minimum of 20 years. Frank's been on the registry for more than 40 years. Come on, folks. If I could sue the stuffing out of DOJ just for that, I would. But I haven't figured out a way to do that quite yet. Don't give up on me, though. I may still figure it out.
Okay. One thing I want to add there, and I want to emphasize this too, is yeah, Janice is right. It seems that older convictions get these letters that say to be determined, But if you do a criminal background, if you go get a live scan, you can see when the conviction happened. You've got a date there. Even if they've destroyed the records or they can't locate them, they did record something at some time, it's on your background. So maybe they should just take a look at their own, CIIs and make a determination based on their own records. That's the one that everybody else gets, and that's the one that everybody else sees. So just a suggestion. I know it's logical, maybe silly.
Thank you, Janice. All right, so we have had some hiccups here. Let's go to the next slide. These are kind of the early tiering issues. We quite frankly were expecting anybody convicted of a misdemeanor was going to end up in tier 1. Big surprise here. We've got people convicted of misdemeanor offenses in tier 3. What? I'm working with one gentleman right now. He was assigned, he was convicted of a wobbler. He got his wobbler reduced from felony to misdemeanor. And when it came time for his sentence, he was sentenced to 90 days in jail, 90. Okay, this is what a big threat he is to society. And yet they have assigned him to tier 3. Now I'm hoping to get this corrected administratively. If not, we are going to sue the government for making such a stupid mistake. And what this slide is about too, people who have had their felonies, which are wobblers. Not every felony is a wobbler, folks. Please understand that. That's a pretty short list. But for those who have wobbler felonies and have been reduced to a misdemeanor, what the heck are they're being, some of them being assigned to tier 3 instead of tier 1. And so I have found one time so far, but I'm an optimist, so I hope that this will continue. This been able to get somebody who had a tier assignment letter that said you are assigned to tier 3. He had a 311.11a. It's a wobbler. He'd had it reduced from misdemeanor, and again they assigned him to tier 3. I said, excuse me, but he doesn't belong there. And they went, oops. So sure enough, it would happen administratively and we didn't have to file a lawsuit. I just don't know how many times we're going to be able to go to that well. Because remember what I said earlier, the California Department of Justice refuses to issue regulations implementing the tiered registry law. So how, and it says, oh, you can challenge an assignment to a tier, your tier assignment, but it doesn't tell you how to do that, right? And so Chance and I and other lawyers were trying to create a method here, but it's really trial and error. Do you want to add anything to this, Chuck?
Yeah, the word sad. Very sad. As Janice has said, you expect that the Department of Justice is set up and understands these things, and works accordingly. They don't. And so what happens is as Janice says, you have someone who has a felony, it gets reduced, and yet the letter comes and it says tier 3, and before you know it, you've got to contact the DOJ and try to work these things out or otherwise sue. And so that's the state of play. The DOJ just it seems to be ill-equipped to deal with all of this, and sometimes really misunderstands the languages, even the language on this slide, reduction for all purposes. That's what happens when you get a felony reduced to a misdemeanor. Some of the justifications that they're using on misdemeanors that are in tier 3 are that even though they're relying on cases that are persuasive, but they're not relying on Supreme Court cases. And so it really is a situation where I think potentially there's going to be a lot of litigation. And then I'll say that for now. Okay.
Thank you, Chance. One of the other offenses, and it's here on the chart, is the 243.4. So that's sexual battery. There's different subsections of sexual battery, and one of the subsections is a straight out misdemeanor from the very beginning. If you're lucky to have been convicted of that offense, you're in tier 1 without question. But there are others that are wobblers. And so again, a wobbler in California is something that is initially a felony, but you can request that it be reduced to misdemeanor. And not always, most of the time that's granted, but you have to go through the step, go to court, get it formally reduced. So what Chance was saying in this last point on the chart is really important, is when you get a reduction to a misdemeanor, that's supposed to be a misdemeanor for all purposes. And there's case law on this and everything. And why is California DOJ being so stupid?
Persnickety?
I'll say
I don't know.
ridiculous. I could use that
Yeah.
one as well. Next chart, please.
Yeah.
Yes, yeah, we can think of quite a few of them. So one of the things that a lot of people are worried about, quite frankly, within the tiered registry laws, what's going to happen to the Megan's Law website. So this part of the law doesn't become effective until January of 2022. So that's a small blessing. But here's the bad part, or here's the good part. If you're assigned to tier 1, you're not going to be on the Megan's Law website. You don't have to do anything about it. However, if you're tier 3, right, you're going to be on the website. And anybody, no matter what your tier is, including tier 1, if you have a well above average risk level, they're going to put you on the Megan's Law website. And again, using Frank as an example, Frank led a pretty normal life until the Megan's Law website basically added him in his profile. And once that happened, his life was no longer normal. All right. So he'd been named Citizen of the Year in Pismo Beach, California, and being Sam the Clam during their seafood festival and everything. And people thought very highly of Frank until they found out that he was on the registry. What? It was the same Frank Lindsay, the same person that they knew, the same person who had devoted countless volunteer hours on the seafood festival, the Price House in San Luis Obispo nearby. I mean, he was considered a model citizen until people found out he was on the registry. And then Frank basically was prohibited from visiting some of the same places where he'd volunteered. So this is my concern for people being added to the Megan's Law website. By the way, there's no way that I have figured out yet, and I don't think Chance has either, because we've talked about it. How do you proactively prevent somebody from being added to the Megan's Law website when you know they don't belong there? We are still trying to figure this out. And I think, unfortunately, we're going to have to wait until somebody's added and then file a lawsuit. But stay tuned for that. Chance, do you want to add anything?
I think that pretty much covers that slide there.
Okay. Why don't you take the next slide, if you don't mind?
All right. Removal from the registry is not automatic. Let me repeat that again. Not automatic. Why? Because if it were automatic, then you wouldn't need anything other than just a petition. If you look at the law, you can see it's a little complicated. You got a petition for it, and a petition is no guarantee you're going to get it. Beginning last July 1st, there's a birthday rule. That means that everybody whose birthday comes before July 1st, you got to wait an extra year until after your birthday to apply. Everybody who has their birthday July 1st and beyond, 2021, gets to apply now. Why is there a birthday rule? I have no idea, but there's a birthday rule. You file in the county where you currently reside, but if you were convicted in a different jurisdiction, you've got to send them copies too. Now it goes like this. You file at the agency that you register at, and you also give notice to the DA's office of that county at the nearest branch office to wherever you live. And you do the same thing. If you were convicted in another in another jurisdiction, and you're living now away from that jurisdiction, you also send a copy to your original agency where you registered at, and to the branch office of the county of the district attorney located near where you used to live. That's notice. Okay, and then we have here on this slide, consideration by local law enforcement, consideration by the DA's office. That's another can of worms altogether. I think we should probably move to the next slide.
Okay, why don't I start this discussion? So what happens when a petition is filed with the court and you properly serve the copies where you need to serve them? Well, local law enforcement is supposed to determine, or at least make a recommendation to the DA's office, whether or not you are eligible. In other words, you're on tier 2, has it been 20 years since you've been on the registry? for example, remember failures to register. What wasn't on that chart was if you went back to custody, jail, or prison for any period of time, that amount of time is not going to count towards your registration requirement, and those kind of things. So I'm not really going to address that because hopefully local law enforcement is going to figure this out. I have my doubts, but we'll put those aside for the moment, because what I'm really worried about is what the DA is going to do. Okay, so the DA is going to review your petition. And by the way, local law enforcement has 60 days, up to 60 days. And the DA's office doesn't have to start counting their time until that's finished. So then the DA's office has another 60 days. So we're talking about 4 months during this process. And the petitions that I have filed, my clients always want to know, how soon am I going to get an answer? And I said, maybe 6 weeks, 6 months rather, not 6 weeks, 6 months. You think 2 months for the local law enforcement, 2 months for the DA's office, and then the court has a decision to make, right? And I think that that's being optimistic. So we're talking about 6 months. So what can the DA do? The DA can say to the court, I think you should deny this because this person's not eligible. Well, maybe that makes, to me, that at least that should be an objective decision, right? But the next one is not objective. Based upon enhancement of community security, we think this person should have to continue registering, even though, quite frankly, they are eligible to petition for removal. And I don't know about you, but this scares the stuffing out of me, because what does that mean? Enhancement of community security. I've seen too many court cases where the government, waves the flag of public safety, which to me is very similar to community security. And the minute they do that, the courts just throw up their hands and say, oh, okay, whatever you say. So I'm very concerned here that DA's offices are going to pull the trigger on this one. There's a long form for the DA's office. Actually, it's not that long. It's only 2 pages. But this is one of the boxes that they can check. If they check that box, there are 2 possibilities. 1, there's a court hearing, and 2, there is no court hearing. So I've had this happen already. And the gentleman up here in Northern California and Placer County, to be specific, we submitted his petition, and the DA's office has said, Judge, we think you should summarily deny this petition, which means there will not be a hearing. Now, my client was so afraid when we got this information that he withdrew his petition. Oh, he asked me to withdraw his petition. Why? Because, in the lunchtime, somebody was talking about the fact in his situation, he was former law enforcement. When he was charged and convicted, it made all the local newspapers. And because of that, he moved to Northern California. That happened in Southern California. So he's very gun shy, if I can use that term, and very afraid that he's going to get media attention because the DA's office has recommended that his petition be summarily denied. Why? What was the basis for that recommendation to the court? Because he didn't get a tier assignment. Okay, but you look at what offense he was convicted of, you look at the tiered registry law. The tiered registry law says that's tier 1. There's no question about it. So why is the DA recommending summary denial of the man's petition just because he didn't get his tier assignment letter or tier assignment? And by the way, when it went back to California DOJ and their letters, the TBD letters, as I refer to them, they backed down and they took a sentence out of their letter that was being sent to all the registrants. So no longer does that letter say, if in fact you that you have to wait until you have a tier assignment before you can petition. So this is a very early test. This man's birthday, he's lucky, I guess, and that his birthday was in July. So we were able to submit his petition real nice and early. But here we are, we've already run up against this. And by the way, it's not automatic, even the withdrawal. I still have to go to court later this month to let the judge know he really wants to withdraw his petition. But again, let's go back to the bigger issue here. And that is, if the DA wants to, they can say, oh, we think this person should continue to register in order to enhance community security, whatever the heck that means.
Okay, so I have a supposition, which is just a guess.
Sure.
But my supposition is this. It's kind of like Fourth Amendment issues, do the police need a warrant? And it used to be that the code word was, or the code phrase was, it's the totality of the circumstances, which really means the situation was so dangerous, we really didn't think we needed one. We didn't have time to get one. We know we needed one, but sorry, we're going to get it. We're going to go in anyway. And whenever you say the totality of the circumstances in court, judges understand that code. That meant we really should have got one, but it was urgent, so we just didn't. And judges usually err on the side of the police. This is very similar to that. This is like, hey, this guy's dangerous. So, that's the code. And the thing is that it's going to get a little murky here because one, jurisdictionally, things are going to be spread out like butter. For instance, the largest jurisdiction is Los Angeles. And instead of having a centralized court and a centralized DA, things are being sent out to branch courts all over the place. And this code here all of a sudden puts the court on notice that the facts and circumstances of the case, which is what this is really, I think, all going towards, are such that the court should deny it. And that's a tough place to start. That's just my supposition, but that's what I think. Janice?
Yeah, thank you, Chance. Next slide, please. Okay, so local law enforcement looks at your petition. The DAs look at your decision, or petition rather, but it's the judge who makes the decision. Okay, so even the DA, whatever the DA recommends, it's possible, maybe not likely, but it's possible the judge can ignore it. So what must the judge consider? These things are must. Now, by the way, when the tiered registry law was going through the legislative process, we asked that this word be changed from must to may. So in other words, instead of mandatory, to make it discretionary. We lost that battle, so unfortunately it is must. The judge must consider the nature of your offense, the age and number of your victims, and whether your victim was a stranger. What? This part, it's another part of the tiered registry law that makes me upset, angry, and confused. These things, and it's because these factors were considered at the time of your sentencing. What the heck do they have to do now with whether or not your petition should be granted? And remember, there are people like Frank Lindsay who've been on this registry for more than 40 years. So regardless of what the factors were 40 years ago, what difference do they make today? But I think more importantly, it's already been reflected in your sentence. What do you think, Chance?
Well, I think this is where the rubber meets the road. And this is what I'm talking about. The nature of the offense and so forth. But let me say two things. One is the artistry here, the real cutting edge of dealing with these things is how your attorney is going to take these on. So it's important if you get into a hearing to be represented, because starting with that first one, nature of the offense, you've got to know how to maneuver that. Now, all the rest of these factors, and by the way, including that one, are all really rebuttable presumptions because they may be totally inaccurate, okay, and aggravated because everything's based on the initial view of the case when you're looking at police reports and everything else, not where the facts really land. And so there's flexibility and space to challenge these things as rebuttable presumptions. And I have more to say on that later, but I'll kick it back to Janice and we can move on from there.
Okay, thanks, Chance. Yes, next slide, please. So in addition to looking at the pre-conviction factors, the judge must look at post-conviction factors. And actually, I think two of the three are great. One is, how long has it been since your offense occurred? I mean, that just seems so basic, but at least the law says that the judge must look at that time period. Next, whether or not you completed a treatment program. And by the way, the lack of evidence regarding the completion of a treatment program should not hurt you. I say that for people like Frank Lindsay, who were convicted so long ago, and maybe at that point in time, there wasn't a treatment program. I can't remember for Frank's situation or anybody else's, but you know, what evidence do you have that your treatment was completed? Do you actually have any hard evidence? I say that because even though the courts are supposed to keep your records for 75 years, guess what? Your treatment provider doesn't keep them for 75 years. And it's quite possible as once you completed your program, or plus, you know, take or minus 2-3 years, they throw them in the trash, or hopefully they shred them before they throw them in the trash for Privacy Act reasons. But that might be difficult to prove for people convicted as long ago as Frank. And then, of course, the last one, the current risk of reoffense. And what are they going to look at that current risk of reoffense? Well, static 99R, unfortunately, is one of those things. Why do I use the word unfortunately? Because unfortunately, that particular instrument is not accurate, and is often not accurate. Of course, I want to say it's accurate for anybody who gets a low score, but the fact is that some people have a high score and they don't deserve it. And let me tell you that any gay man under the age of 25, you are high risk on the static 99, and that is totally wrong. But that's the way that test, that instrument is skewed. It basically, to me, is homophobic. And so, because if you're under 25, you get a point. If you're a victim of the same sex, you get a point. These other things that happen. I do not even know of one young gay man who's not at least a 4, which is considered moderate/high risk, which they consider high risk. Again, makes me a little crazy, but it is what it is. Now, how can you possibly get around this? For many people, your static 99 score is an old score. So Frank Lindsay didn't even get one because they didn't have it way back when. But there are other people who might have a risk level that was established 20 years ago. The way to get around this, I believe, is you go get a current risk assessment, right? So you're not 25 years old anymore. Now you're 42. You're not this, you're not that. Maybe your risk level would be reduced. And by the way, if you go to a psychologist and you get your risk assessment done, if it's not in your favor, you don't have to tell the government about it. Okay, that's a time when you put it in the back of your closet, shred it, whatever you want to do with it. But the fact is, if you have a low risk level, then you can share it with the court, but only if there's a hearing. Okay. So one of the things we didn't say, Chance, that maybe I should say now is when one files a petition, there's the only document you can file with it is your proof of registration. So for those of you who've had a certificate of rehabilitation, your proof here that you completed a treatment program, whatever it is, letters from everybody telling you, the judge that you walk on water, you're such a wonderful person. No, you cannot submit that with the petition. It only becomes relevant if there's a hearing. And that's to me then makes it very concerning that what happened in Placer County, where the DA's office is recommending summary denial. So they want the judge to deny the petition without a hearing. Okay, where's the due process on that? I think there's a complete lack of due process. But anyway, back to the charts here about post-conviction factors. This is, by the way, if indeed you have a hearing on your petition, please get a lawyer to go with you, a lawyer who knows the law, because it is going to be an evidentiary hearing, and you will not do very well if you don't have a legal representative with you at the hearing. The good news is not everybody's going to have a hearing. Some petitions are going to be granted without a hearing. But again, if you find out that there's going to be a hearing about your petition, please have a legal representative go with you. I bet, Chance, you have something to say about that.
Well, yeah, well, kind of, but before I do, I'll just digress here a little bit and talk about what objective factors you may see. And Janice is right, you can't attach any of that to your petition. But what you can do is you can have all these mitigating factors documented without having to attach them to your petition. How do you do that legal hocus pocus? I'm going to tell you that right now. One is you can get an early termination of probation, you can get a dismissal, you can get a reduction, or a certificate of rehabilitation. Now, forget about the early termination of probation for right now, and let's just talk about those other 3. They're all recorded in your CII or criminal background. So in your life scan, they're all going to be there front and center so that everybody can read them. And so you're not going to be able to use it when you petition, but when law enforcement looks at your background and when you're examined through the DA's office, that's going to stick out because all of those are mitigating factors. And so, those are really strong objective factors in mitigation. They soften the whole effect of the harshness that a DA may come forward with initially. And let's see. I'm sorry, Janice, I got lost in that thought.
Okay, well, why don't we move to the next slide then? So the next slide is thank you. If you all want to reach us, here's the this is how to get to our website. We have a lot of information on the website about the tiered registry. You can send a message to Chance or to I using our website, and I usually get the first peek at it, and then if it's something that Chance needs to see, I will forward on to him. So we are here for you, and we want you to use us as resources. Folks, this is a brand new process. There's more than a few hiccups, bumps in the road. As we've mentioned, there's been some other ones as well that we didn't mention because they're so specific to the client. But the good news is, here's the good news. 3 people in San Diego County have had their petitions granted. So I'm so thrilled for them. 2 of them, I believe, were convicted of 288(a) lewd or lascivious acts with somebody under the age of 14. So we have 3 success stories already. And in San Diego County, I understand there's 2 more that are pending and that are expected to be granted soon. What San Diego County has done, according to one of our board members, who you heard from yesterday, Alex Landon, that if the DA's office does not object to your petition, the court will just grant it. So think about it. It's not been much time. It's been a pretty short period of time that anybody could submit a petition. And during that time, San Diego, let's just give them the benefit of the doubt, has granted 5. Okay, I don't know of any other county granting any, but anyway, I'm glad that we do have some good news there. Back to the petitions that I have filed, I've probably filed a dozen of them so far. And in those dozen, we're getting all kinds of different answers or responses to the petition. And some of them we have hearings scheduled 6 weeks after the petitions are filed. And that doesn't make sense to me. Because remember, the local law enforcement gets 60 days, then the DA gets 60 days. We're talking about 4 months already. Why are you going to have a hearing in only 6 weeks? And I don't know what these hearings are. Maybe they're just a status hearing to make sure that the court process keeps continuing. Somebody, they don't drop the ball. I'm not sure what it's about, but I do have some hearings that are scheduled out more than 6 months from now. And that makes me afraid as well that this is going to be a hearing on the merits. But how do they know now? I mean, that's why it doesn't make sense to me. Why do I have a hearing scheduled in January of next year for a petition that I filed in July of this year? I just don't know. But but I'll find out soon, I hope. There was a question asked, and so I'm choosing the easy one first, which is where did it go? It had to do with will be eligible in July of 2022. It says, assuming you're eligible to petition to get off the registry in July 22, can you file the petition to start the ball rolling before that? No, please, folks, don't do it. Guess what's going to happen? You submit your petition, it's going to be thrown out. Okay, you don't want to do that. And the one reason is that if it gets thrown out, they might make you wait 1 to 5 years before you can submit a new petition. So don't shoot yourself in the foot or anywhere else. There was another question here. Oh, it had to do with the 288C1 Tier 3 lawsuit. No, we're not going to refile that lawsuit because we're going to appeal the decision that we got. So we did file a petition, and Chance, you mentioned it earlier about the difference between 288A and 288C. Makes no sense whatsoever. You're going to have somebody with a younger victim, the 288A, right, under 14, assigned to Tier 2, and people 288C, that's 14 or 15 is Tier 3. What? Again, makes absolutely no sense. And so we, in fact, filed a lawsuit. The government filed a demur, which is like a motion to dismiss. So we're going to appeal that. I think we're going to be in court for a while on that one. And it's maybe not so much even about this decision or this topic, but the courts do not like cases of first impression. Judges don't like cases of first impression. Every time I have one, the judge grants a demur because they're trying to duck out of the case. They don't want to make that decision. It's a hard decision. They don't have a direct precedent, and so they run the other way.
But we are on it. Janice is on it. Don't
Oh,
worry about it.
I am
We're
like, you know,
moving forward, so have faith, have faith.
yes, we are. So there's no need to file a new case. We have that. But Chance, here's a question. To the best of your knowledge, has LA granted any petitions yet?
I have not heard of any granted yet. I have filings in the tube myself, and I'm in just I have people call me every day and go, "Are we there yet? Are we there yet?" But we're not there yet. But as soon as I find out that we're there yet, I will make results public so that people know exactly how this jurisdiction is responding.
Yeah. So folks, don't call your lawyer every day. You're not going to get a nice answer. If you get an answer at all, it annoys me. Just think about it if you can from this perspective. There's over 100,000 people on the California Registry alone. Think of that, 100,000 people. There's Chance and there's me. Oh, by the way, there's some other lawyers out there who are making promises that they can never fulfill. If you hired them, good luck. But the fact is that, there's only so much that we have control over. So what I do, for example, remember, I'm filing your petition in court. And then once we get the confirmed copy of that petition back from the court, I send it to my clients. And why? You got a case number, number one, you can follow it online, most of these superior courts. And number two, if you have a hearing, the hearing date and time is right there on the confirmed copy.
And remember, this is so new. I mean, we're the process just started up July. We're just in September. So I'm and you know what? Probably the simple answer to that question is I'm sure that simple petitions like in San Diego have been granted. And I am just so impressed about what's happened in San Diego. I am, and that's a ray of hope. So let's hope that it's progressive and it goes forward just like that everywhere.
Okay, so I'm going to be a wet blanket. Sorry, but some people would say reality, and that is a rumor. It's nothing more than a rumor we've heard about Riverside County. And the rumor we've heard is that the DA in Riverside County is going to object to every petition. Now, that doesn't necessarily mean that the judges will agree with the DA's office, but it often is the case. And I'm just hoping that if indeed they do object to petitions, then at least there's a hearing so that Chance and I and the other attorneys can bring this evidence to the forefront. By the way, Chance and I are private attorneys, and we do expect people to pay us for the work that we do on the petitions. I do other stuff for free as the executive director. But in addition to Chance and I, there are a lot of public defenders' offices who are now helping people. So you might want to put aside what you think of public defenders in general, and at least give them a try, because they're not going to charge you any money and for doing that. And but I will say not every public defender's office does have the resources. They haven't set aside the resources to help people with their petitions. We have on our website information about the DA's offices that have set aside resources and how you can contact them. So please give that a try. So here's a question for you, Chance. I had my wobbler reduced to a misdemeanor 326, maybe that's a date, and I was supposed to be reduced to tier 1, but I'm still tier 3. I contacted California DOJ, and all they did was give me an email address.
That's nice. Sometimes the DOJ ignores you when you contact them. Sometimes it's more effective to have an attorney contact them and send the documentation to them. I've had that issue a lot this year, actually some last year and a lot this year. And what I do is I send an email and I attach documentation so that everybody knows, that it actually happened. And then they usually get back to me. They confirm they receive it and they act on it. And I'm really happy to say that I've never had anybody left out in the dust that way. But they are also very slow because they are trying to handle so much, and the system is so bogged down and so overwhelmed that I think that lag time is something that's now become the new norm. So just understand that. But yeah, they don't respond very well if you're contacting them. They respond much better when an attorney does it.
So I'm going to answer one last question, and then we got to go because our time is up. And that is there any downside to getting a live scan done? No. And so might you want to get a live scan report done? Honest to God, I have people calling me up, asking me for advice, and they don't know what they were convicted of. And you know what? If your profile is correct on the Megan's Law website, then I might be able to tell you what you were convicted of. And by the way, nobody who has ever been convicted of Penal Code Section 290. That's the requirement to register Penal Code Section 290. You were convicted of something else. So please don't say that. The other thing is, and I will say for Chance and myself and every attorney you call, when you call us, please have paper and pen ready. We're going to give you information. You called us for information and you need to be ready to write it down. I know it's old fashioned, paper and pen, but don't be expecting Chance and I to send you text messages and emails and all this other stuff because there's over 100,000 of you. Number two, when you call, please be in a quiet place. I had somebody call me last week and I'm like, oh my gosh, I couldn't really understand what he was saying. I said, excuse me, but where are you? He says, I'm in the middle of a Mexican restaurant, right, to pick up my lunch. And I said, well, call me back when you're not in that noisy restaurant. I mean, folks, come on. Chance and I were miracle workers, but if we can't understand you, what you're saying, or it's so noisy in the background, we can't help you. That's all I want to say in closing. Chance, what would you like to say?
Just one more thing about the live scans. Not only does it help your lawyer understand your situation, but if there's an inaccuracy or anything's wrong there that other officials are going to look at and make a mistake on, it can be corrected. They give you a chance to correct that inaccuracy, and I think that that's something that you should do straight out. You should know exactly where you are as far as criminal background, so that you can correct these inaccuracies before you get in court and they make a mistake and it holds you back for 2 or 3 years or longer. So, and other than that, I just want to thank everybody. Thank you for joining us. It's been wonderful seeing you, and it's been wonderful doing this with Janice. Thank you, Janice, for inviting me to do this.
And thank you, Chance.